Welcome to Dealmaking with Laura DiFrancesco, the ultimate podcast for entrepreneurs and professionals eager to master the art of acquiring businesses. I'm Laura DiFrancesco, a seasoned M&A attorney and founder of Dean Street Law and a few other businesses. Join me as I demystify the complex world of mergers and acquisitions with in-depth insights and practical advice. Each episode is packed full of expertise, featuring discussions on the critical aspects of the acquisition process, from identifying potential opportunities to negotiating deals and successfully closing transactions. Whether you're a first-time buyer or a veteran investor, this podcast equips you with the tools and knowledge needed to navigate the mergers and acquisitions landscape with confidence. Welcome back to another episode of the Dealmaking with Laura DiFrancesco podcast. I'm so excited that we continue our conversations into deal making. I hope you enjoyed the last episode with Alex from Rejig. It was a fantastic fireside chat conversation that I'm excited to bring to you on the podcast. I'm also excited to announce that we're going to be having a future episode with Alex and Bobby from Rejig as well. We've done a couple deals with them and they have been fantastic to work with. If you're not familiar with Rejig, we'll include all their information in the show notes below, but they are a wonderful platform if you're buying a business and looking for a platform to be able to view businesses, as well as a seller looking to list their business. So definitely check it out. Highly recommend. They have a fantastic platform and are wonderful to work with. So I am excited to dive into today's topic, which is all about closing the deal. If you are in the deal making process, I know you understand how challenging it is to get from a signed LOI or even from the search phase to the signed LOI, then to closing. And of course, this is just the beginning of your journey and there's so much more to come in operating and exiting a business. So the closing part is the final sprint, making sure all of your T's are crossed, all of your I's are dotted, that you have every single document necessary and your legal team is your quarterback in this process. We have closing checklists. We're taking you through the process. So our Dean Street Law process is very different than what you'll see working with most law firms. The reason being, we have closed over $10 billion of transactions just since starting Dean Street Law. I have closed probably well over $20 billion or $30 billion of contracts, if not much more than that in my career in its entirety. So to say we have done this a number of times is quite an understatement. And we are very focused as an entrepreneur myself on making sure that our client experience and the seller's experience, all parties' experiences are as good as they can be, that the process moves as quickly, efficiently as possible in the most successful and productive way that we can. And so we constantly think of how can we set our clients up for success? How can we prepare them for this process? So at the very beginning of our engagement, unlike most law firms you will work with, if any at all, we not only provide the due diligence request list. Let's say you have signed an LOI. Not only do we provide due diligence request list, but we also provide the closing checklist and timeline before we even start drafting. So you can see comprehensively what we at a minimum expect this deal to involve. And of course, that will evolve over time. We will add to it. We will update it. We have it all auto-populate with dates based on your target closing date and your LOI start date, because there are some recommendations generally we have in terms of timing. For instance, that due diligence be focused on the first 30% of your transaction timeline, because you will be astonished how long it takes to get those transaction documents completed and finalized. Not only does it require your attorney or an attorney on the deal drafting the initial draft, but then that second draft can take 3 weeks, can take a month, sometimes longer. So you really want to make sure that you have those accounted for and that you have sufficient time to prepare for closing. And so we arm our clients with that information. We also provide them with a material deal terms list so that they can see what information and what key terms are still in flux that are really going to drive the deal. And so we also ask questions on that, and we encourage them to set up weekly meetings with us so that we can have a touch base each week so that we're making sure they know what we're working on, we know what they're working on, there's open communication. We find all of these steps to be really transformational in the experience of a transaction, both for our clients and the opposing parties. This is important because especially if we're representing the buyer is very invested in this process. They're investing a lot of funds. They're looking forward to their future after this. These sellers are much more apprehensive about this process than the buyers are. And so if we communicate to everybody what the expectations are from the beginning of what this will take to get to closing, it makes sure that everybody is transparent, that they're prepared for this process, and that they know what to expect so that it doesn't come as a surprise. I will say I've seen a lot of law firms and a lot of parties wait until the very last minute to draft transaction documents, and that's just a recipe for disaster because it becomes a very stressful process if you leave so much of the transaction to the end. That's why we are very forward thinking. We're preparing our clients. We're very proactive in our approach and our representation of our clients, because having a smooth process where you are continuously working towards closing means that the parties have confidence that the deal is moving forward. The seller wants to see momentum. Also, momentum of the transaction generates a likelihood of success of the deal moving forward. When something stalls out, it really starts to degress and degrade the forward progress that you've made on the transaction. So it makes getting to closing considerably harder when you stall out. That's why we are always communicating. We have all of the parties understand the expectations of what's needed to get to closing, and we work diligently through those processes with our clients and with the other parties to the transactions. All of those are fundamental components of a successful transaction closing. So let's get into a couple of the details around a closing so that you're more informed about what the closing process is like and what to expect, and of course, what to expect when working with us. I have my notes here to make sure that we aren't missing anything, just like I have my closing checklist. So if you're watching on YouTube, you'll see I might reference my phone and everything. Just want to make sure we're not missing anything. Just like we go through that closing checklist, make sure we have absolutely everything as we're preparing for closing. So let's dive into it. Part of the process of getting to closing is going to include due diligence. We've gone through this in one of our prior episodes, so if you want to dive deeper into due diligence, go check that out. It's a wonderful conversation we've had to give you some more insights about what to expect in the due diligence process. But how does that prepare you for closing? Now, of course, you need to complete due diligence. Due diligence is not just checking the box. It's making sure that risks are allocated appropriately, that you know that the business you think you're buying is the business you are buying. And it's going to not only inform different aspects of the deal, how things need to be structured to legally transfer the business, and for that transfer to be legally binding, which you want as the buyer, but it's also going to drive some of the deliverables for your closing checklist, for your transaction as a whole, because it drives structure, it drives terms, and of course then that is all going to flow into your closing checklist and what's going to be needed to get to closing. So we, of course, in our due diligence process, review all of the documents that are provided. We also provide a chart report to all of our clients who are buyers buying a business. On the sell side, when we're representing sellers through the due diligence process, we assist them in populating that data room, in advising them on how to answer the questions and what they're asking, and overall advise them on the entire process to make sure that they're complying with the requests of the buyer, but also making sure that they're not disclosing information that is, let's say, personal information not relevant to the deal, or accidentally disclosing things that aren't at all related, right? We want to make sure that the answers are relevant to the buyer's questions. So when we go through that process of due diligence, we're reviewing all those documents, preparing the report, and we will, especially by reviewing all the contracts in due diligence, understand what approvals, third-party approvals, regulatory approvals are necessary for closing. Also, what consents are going to be necessary for closing as well. As I mentioned, due diligence directly drives your closing deliverables. So you have to complete due diligence no matter what to be able to buy a business. It's non-negotiable. Now, the amount of due diligence that you complete, that you can decide what risks you're willing to take on, but there is a fundamental amount of due diligence that is necessary for every transaction to legally transfer a business. And consents, third-party approvals, consents of the owners, all of those are going to be the most common. Regulatory consents, all of those are going to be the most common elements, but not the only elements that are especially important in the due diligence process. Of course, in the due diligence process, you also have to know what's the legal type of entity, where is it registered? Is it registered in one state or multiple states? Legally, how are we going to transfer, if it's an asset purchase, all the different classes of assets? If it's a stock purchase or membership interest purchase, how are you going to legally transfer those membership interests? So there's a lot of fundamental due diligence that's necessary and will drive your closing deliverables, especially approvals, clearances, and also anything else that you need to do. Notice to some parties if approvals aren't required or consents and whatnot. So that's due diligence in a nutshell. I really, truly recommend that you revisit our conversation about due diligence in further detail so that you can dive into that in more detail. When it comes to navigating corporate law, entrepreneurship, and managing small businesses, experience matters. Dean Street Law is a boutique corporate firm specializing in mergers and acquisitions and additional focus in real estate, commercial transactions, finance, and corporate governance. With over $10 billion in deals closed, Dean Street Law has extensive experience representing hundreds of clients in thousands of transactions, from small businesses to Fortune 500 companies. Whether you need startup guidance or advice on closing multi-million or multi-billion dollar deals, we're your trusted partner every step of the way. Visit deanstreetlaw.com to schedule a complimentary consultation. Now, during the due diligence process, during the negotiation process, and during the LOI, there will be a target closing date. And the key term there is target, because this moves a lot. And usually the parties have one intention and it doesn't quite go as planned. As we've said in prior episodes, I do really recommend that you include enough time in your exclusivity period to account for the need to have time to close. That's not just your target closing date, but that's extra time because there may be delays, there may be additional things needed by the bank. It may be hard for the seller to produce certain documents. They may have to go through different records that they may not have looked at in a long time. So there may be a number of things that can delay a target closing date, but we do call it a target closing date because that is the idea of what the parties are working towards. I love a realistic closing date. I love a realistic target closing date that gives the party sufficient time to do their job, each of their jobs, effectively and well, because you do not want this to be a rush and shambles. I have been in deals where we've closed a $50 million deal in 2 weeks. I can assure you, you do not want to see the legal bill for something like that. It was, I think, a $50 million deal, right? So like it was an incredible legal bill to begin with, but then when you condense it, it is even more so. Unfortunately, the buyer did not do sufficient due diligence. And guess what? A week after closing, they found out that the business was almost bankrupt. And it had no working capital. It had no cash flow. It was in workout immediately. It was rough to see that happen. You need a certain amount of time to actually get the business that you think you are getting and to make sure that the business you think you're getting is the business that you're getting. Don't cut yourself short. Don't shoot yourself in the foot by not giving yourself enough time in your target closing date to be able to sufficiently do everything that the parties need to do to get to closing. It's essential. You absolutely need it. It's quite different than buying real estate. Buying real estate doesn't change so drastically. Buying real estate doesn't require as much due diligence for the most part. There's complex real estate deals. I understand that. I've been a part of plenty of them. But for the most part, just don't think that it's like buying a car or buying a piece of real estate. It's so much different. So we want it to be reasonable. We've talked in prior episodes. If you're getting financing from the bank, expect 60 to 90 days. If you are fundraising, expect 90 to 120, assuming you've already done a lot of fundraising legwork. If you haven't done fundraising legwork, you may need more than 120 days, just to be honest. And as I said, you want that LOI to include sufficient time. Now, if it doesn't, always include a mechanism for extending that time automatically upon consent of the parties, anything you can get. If it's a competitive situation, you might not be able to get as much, but whatever it is, it's a really bad position to put yourself in, to have executed an LOI, to have spent money pursuing a deal, and then it get to the 10th hour. And at that point, the business may have appreciated in value, and the seller may not desire to extend the time period to get to closing unless there is an incentive, perhaps a deposit that's made or something like that. So even though you want a reasonable amount of time that you have set forth for the due diligence period, for drafting transaction documents, and ultimately your target closing date, yes, that will move. And that's understandable. The most important thing is that you have good open communication between the parties, especially if you need to extend the LOI exclusivity period. We track that extensively and make sure that if there is an LOI amendment that needs to be made, that we are making that as quickly as we can. And of course, before that LOI extension period needs to be completed. So if needed, we can extend it. But you do want to make sure that you have exclusivity until closing, ideally. And then also you have open communication between the parties going towards closing if there's any changes in the closing timeline. It's really important because managing open transparency, expectations between the parties, there are a lot of people involved and a lot of people spending money on different advisors and different vendors to be able to get to closing. And it's fair and respectful to have those transparent, open conversations about the expectations for the closing date. And when you know something has to change, to communicate those. That way no one's expending extra money by documents being finalized when they're not even ready to be finalized. So let's talk about some last minute things that may change, last minute things that need to be addressed, and some last minute challenges overall. As I mentioned, it is a really bad practice to wait until the last minute to have ancillary documents drafted, to have documents that haven't been circulated. You want to be moving expeditiously through that transaction timeline so that it is forward progress, moving towards closing, and not everything is left until the end. You want to make sure that you are able to give your advisors, your vendors, the amount of time that they need to do their job properly. And so that all of the parties don't have this huge bubble of stress right before closing, and it's a monumental decision on everybody's parts that can create an environment for the deal to go south when it doesn't need to be the case. So typical challenges that you'll see is, one, if they don't have, that perspective, then maybe someone's waiting until the last minute. Anyone on our deals knows that we're very proactive, and that's not something that we do, but that does happen in a lot of deals that we've heard about. The other is financial discrepancies. So you do want to do your financial due diligence early on. And then I always recommend the parties that the seller starts closing the books monthly and potentially weekly leading up to closing, and that those financials are delivered to the buyer along that transaction timeline. It's really important because you don't want financial changes to come up last minute that could really have been discoverable or known to the parties early on. Particularly the buyer, you're expending funds throughout this process. So having the sellers close their books monthly to the extent possible and deliver financials on a regular basis, that really helps to reduce the likelihood of this challenge. The next is legal obstacles. So if you didn't complete your due diligence early, you don't know what approvals, consents, notices need to be sent, then that will also back up things that need to be done to be able to get to closing. And if you don't have those, you can't close. And so some of them may be waived by the parties. So certain consents or approvals may be a bonus and not necessary according to the due diligence materials and transaction documents. So some of them may be accepted by the parties as post-closing deliverables. But if it's not accepted by the parties and or it's required for closing, the closing cannot occur until those do. And so you're just going to have to push back the closing until those closing deliverables are in hand, good to go, ready to get to closing. Proactive solutions. I highly recommend having contingency plans or thinking through various scenarios. Let's say you have to get certain consents to close. Okay, so let's think through if it's a regulatory consent. Please add a couple months to your transaction timelines. Regulatory consents and approvals and governmental consents and approvals, that you're generally looking at 2 to 3 months at a very minimum. Sometimes you're looking at 6 months to a year. Just depends on the regulatory body if they have required response times or not. Think of those with a lot of extra padding in there to get a successful closing. But for the other ones, what happens if you can't get an approval? Do you change it from an asset purchase to a stock purchase so that if it's not required under those transaction documents to get an approval, that you don't need the approval? Can you do that preemptively so that you don't have to seek that approval to be able to go to closing? What can you do to create an environment for success for yourself? And this is not something you need to worry about by yourself. This is something that we as your attorneys specialize in, have a lot of experience in. We've navigated these a number of times. So have a conversation with your attorney, with your providers to be able to work through what can we do if this doesn't work out or if this takes longer than expected. Thinking about buying a business? Unlock the secrets of successful acquisitions with Acquisition Insights, your legal roadmap for success. With over 81 modules of video lectures, written materials, guides, and checklists, we provide in-depth guidance to navigate every step of the process. From initial interest to closing the deal, get the expertise you need to make informed decisions. You can also access our battle-tested templates in the Acquisition Insights course and templates bundle, including letters of intent, pre-LOI and post-LOI due diligence request lists, material deal terms lists, and more. Visit lauradifrancesco.co/the-shop today and take the first step towards buying your dream business. How can we set ourselves up for success? That is the question that I ask myself on a daily basis, not only with respect to clients, but also with respect to my businesses, my life as a whole. How can I create an environment for success? That means that success will become inevitable. It will not be something that I'm constantly pushing hard against. Success becomes inevitable when you start creating an environment for success for yourself. Others, of course, speak to your attorneys, speak to your experts, speak to your advisors. What are solutions? How can we navigate this? And then, of course, from a practical standpoint, the things like I said before, communicating openly about transparency around the target closing date, working proactively throughout the entire period, making sure that you have good communication between the parties of exactly what's necessary. That's why we send out the closing checklist before we even start drafting transaction documents. Yes, we update it over time, but it is critical, mission critical, that all of the parties know exactly what at a minimum is necessary to get to closing. That creates an environment for success. Absolutely. So let's say you're getting ready for closing. Let's talk a little bit about the procedures and what you can expect getting ready for closing. So I think a lot of folks think from the business perspective that they can just say, oh, we're closing tomorrow. And then it's that easy to close tomorrow. There's so much that goes into closing. So one, we need to make sure that all the documents are finalized. We personally have a system and method of going through this. As we draft the documents, we always have anything open, bracketed, and highlighted. So we can search through the documents, all the transaction documents for a bracket, and know exactly what needs to be finalized before getting to closing. This is one of the tools that we use to have a seamless process as we're representing our clients throughout the process of buying a business or selling a business. So finalizing the documents, you may think that's simple, but when you have 15 or more transaction documents and even things as simple as addresses that you need to get. So we work on finalizing the transaction documents as we go. This is not something that we wait until the last minute, although you will see a lot of people do that. So I love to ask, what are the addresses? Give me all the details. I don't want to have anything in brackets unless it's being negotiated and it's currently an open issue. There shouldn't be things in brackets that are just questions we need to ask. Those need to be asked early on and ahead of time so that finalizing the transaction documents doesn't take days. It hopefully just takes half a day. And then in addition to finalizing the transaction documents, every party needs to sign off on the execution versions. So once you have finalized transaction documents, you have to create execution versions. Execution versions are dated versions that have absolutely everything filled in. So most things are going to be bracketed. That's information you need to get to closing, but certain things are going to continue to change up to closing, such as the date of documents or relative dates that are based on that date. It may just be a date. It may be other things that continue to evolve up to closing or around closing. This could be financial numbers or other impactful provisions. And so all of those need to be finalized, and they need to be execution versions need to be prepared based on final numbers or final dates or anything like that. Just creating execution versions for, let's say, 10 to 15 documents is going to take half a day to a day minimum. The reason that is because you have to go through everything with a fine-tooth comb. Yes, we of course have that system to foolproof things, so we bracket everything, but that means that every document is reread in its entirety as well to make sure absolutely everything is good to go. In addition, not only is the Word document put into an execution version for approval by the parties, but it's also converted to a PDF so it may be executed as well. And then in addition to that, you need everybody to sign off on all of the execution versions and for them to be uploaded to a document signing system. Now, you could have closing in person, absolutely, that does happen, but a lot of times, even when the closing is in person, unless something needs to be notarized or it needs to be wet ink, as we call it, because of certain statutes or requirements, most of them are signed electronically, even in an in-person closing. And so just uploading those 10 to 15 documents and then having all of the different elements that filled out by who needs to sign what, if there's a signing order, whether it needs to be signed, initialed, all of that, so that it's as little information being filled out at the signing as possible. And then it needs to be prepared for signing. So as I said, you're at a minimum looking at half a day to a day. And that's assuming that we've been doing all of our work prior to closing to get the documents in finalization, ready, order, and status. I will say we have a really fancy closing checklist that I absolutely love. I designed it. I geek out on Google Sheets. I'm not going to lie. And I designed this closing checklist so that not only auto-populates with all of the suggested dates, and then of course we can edit that if there's any discussion between the parties, but it also has drop downs as to the status of everything. It's beautiful. Chef's kiss beautiful. So it has drop downs of in progress, not applicable, completed, to be executed, execution ready, final, something like that, signed, etc. So all of our statuses can be updated and it can be clearly seen what status everything is. And of course, notes as well, if there's any notes about different things that need to be addressed in the transaction closing checklist and timeline. So I love it, I have to say, just to continue to share about my little Google Sheets. So it also has this timeline to the right of all of the deliverables that show you a graph of the timeline in the transaction that it will be working. So if you're a visual person, it also has that fun little element. I just love these things. I feel like it makes our job, everything that we do. When I spend time to help our clients to develop these resources for our clients, it not only helps them in the single client that we help, but it serves all of our clients. And of course, you know, if you've checked out Acquisition Insights, we do provide our material deal terms list, our closing checklist and timeline template, and a number of our other templates as well, all in the Acquisition Insights course and templates bundle. So if you are trying to minimize your legal bill and you want to get started on these things and do as much as you can yourself, I do recommend getting Acquisition Insights, the course and templates bundle, and then you'll be able to see the absolutely beautiful closing checklist timeline that I have created. So It's something that I'm very passionate about, making sure that we are the best that we can be at every single thing that we do, and we constantly upgrade our experience for our clients and those that we are involved with in the deal making process, something that's near and dear to my heart and that I'm very proud of. So when you're going through this process, I talk exactly how long it took to finalize and to prepare execution versions of the documents. And then everybody needs to review them. Even if they signed off on the execution versions, most people aren't just going to go sign, 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 sign. They're probably going to also spend time to look at it. So given that, we have a best practice where we recommend that closings generally take place between Tuesdays and Thursdays, because Mondays, if you have them then, you're not going to have enough time to prepare execution versions. Unless it's mission critical that you close on a Monday, we generally don't recommend it, because you're not going to have that time necessary to finalize the documents, get the final numbers. A lot of those are going to be pulled Monday morning, and then you're going to need half a day to a day to finalize, prepare execution versions. So for that reason, we recommend starting closing generally Tuesday through Thursday. We don't recommend Friday, because if for some reason things are delayed, then you can't just do it to the next business day where things change. You have to generally do it on the following business week, and things may materially change on a Monday versus a Friday versus a Tuesday versus a Wednesday. That's generally what we recommend. In addition, in terms of the time of closing, we generally recommend 11 a.m. to 2 p.m. be your closing window when you schedule closing, because you're always going to need to do something the morning of. So don't expect a 9 a.m. signing. That's very difficult. Even if the documents are prepared, execution versions are prepared, there's usually enough things changing and still in flux that it needs to be prepared or updated day of. And then in addition to that, there may be closing deliverables such as a working capital statement or an estimated working capital statement that needs to be as of the date of closing. So there's a number of things, even if the documents are ready to be signed, that still need to be delivered as closing deliverables day of, that you're going to need some time to process. And then we do recommend scheduling closing before 2 p.m. because usually wires close. You do want to ask your bank, when do wires close? When are wires stopping being able to be initiated and being able to be processed? And this may be an East Coast time, it may be a West Coast time, it may be a Eurozone time. It depends on your bank, it depends on what financial institutions you're working with. But you want to ask this because sometimes it may be 4 p.m. Eastern or 5 p.m. Eastern. And even though you're on West Coast time, if it's an East Coast closing time, you need to plan to have your closing window at least a couple hours prior to that, so that if there's any delay during closing, that you're able to still close the same day and not have to redate everything and re-prepare all of the execution versions, etc., because there was just a couple hours. So always give yourself a couple hours, the morning and the afternoon, to be able to accommodate any flexibility needed on the closing day. And then there's post-closing deliverables. So these are going to depend on your transactions, whether something's mission critical to be completed at closing or whether something may be handled after closing. And then there's just a standard number of things that need to be handled post-closing. If it's an asset purchase and you're taking on the name of the company, usually the old company needs to change its name and or dissolve as one. Another thing, if the parties are doing a press release and want to plan a press release together, that might be on the closing deliverables. If there's a notice that needs to be sent within a certain period after closing to key contracting parties, that may be a post-closing deliverable. So all of those will be handled post-closing. It will be listed on your closing checklist. If you have a competent attorney representing you, of course, if you have us, we will, of course, address those in great detail. So I hope this has provided you information about the closing process. I give you cheers to many successful closings, and at least the successful closing for the deal you're working on. It can be a significantly more stress-free process. I can't guarantee that it's not going to be stressful, but it should be smooth. It should be moving consistently forward. It should not be a shamble of throwing things through the air and things being tossed back and forth and a billion emails the day of and no one really knowing what they're doing. Create an environment for success for yourself. It is possible, it is feasible, and it's certainly something that we do in representing our clients. If you'd like to learn more about this, please feel free to check out Acquisition Insights. our digital course on the legal aspects of buying a business, over 81 lessons, and we have the acquisition course and templates bundle as well, where you can see our closing checklist and timeline, material deal terms list, due diligence request list, and so much more. In addition, I would love it if you need any deal support, if you'd reach out to us, schedule a complimentary consultation at deanstreetlaw.com. We will have all the links in the show notes. And thank you so much for joining me on this episode of Deal Making with Laura DiFrancesco. Cheers and happy deal making. Thank you for joining us on this episode of Deal Making with Laura DiFrancesco. I hope you found today's discussion insightful and that it brought you one step closer to mastering the art of mergers and acquisitions. If you enjoyed this episode, please make sure to follow and subscribe to Deal Making with Laura DiFrancesco on your favorite podcast platform so you never miss an episode. And if you found value in our discussion, please make sure to leave a 5-star review and share the podcast with anyone who may benefit from it. Sharing our podcast is the best way to show your support and help us to continue making more content just like this. So please be sure to take a screenshot and tag us on social media whenever you can. For more in-depth resources, be sure to visit our website at deanstreetlaw.com, where you can find articles, guides, and more information on our services. Or you can also visit lauradifrancesco.co/the-shop for more information on our legal courses. Don't forget to follow us and connect with us on social media for the latest updates, tips, and exclusive content. You can find us on LinkedIn, Search Funder, at LMDFrancesco on X, and at Dean Street Law on Instagram. Be sure to join us on our next episode, where we'll be discussing more deal-making tips and insights. I'll see you there.